Start. Good, teacher.
National Law School of India University. National Law School of India University, Bangalore. Is the frame all right? Yeah. Okay. And Matthew has a number of great academic publications to his credit. I'm not going to go through that list. But most recently, he's written this wonderful book called The Communal Constitution, which is called India's Communal Constitution. Sorry, in case you had doubts about which country's constitution we were talking about, which I thought was a kind of really deep and insightful account of the underlying basis and the underlying thought processes that lay behind some of the work that was done during the framing of the Constitution. And it's not a book about the framing period, as he has written very clearly. It goes both behind that and beyond that to look at some of the more foundational basis for the ideas in the Constitution itself. And I found it particularly interesting because, as many of you know, I've written a book called The Colonial Constitution. I think the names have a certain ring to them, but it's a very different kind of book in terms of treatment, but makes a similar argument in the sense that we need to go beyond simply celebratory accounts of the Constitution. This is not to say that we don't admire the Constitution and don't think that it was a spectacular feat in 3 years. But we need to go, if we really care about the Constitution, we need to understand it in its entirety. We need to critique it when necessary, because that is what keeps the health of a constitution vibrant. And so I think both the books are in the same page. So we thought it'd be good to have a discussion on this. Matthew, thank you very much for coming. So before we get into some of the arguments that you make, I wanted to ask you what made you want to write this book?
Well, the motivations are two broad motivations. One of which, as you said, is to push back against the overwhelmingly liberal characterization of the Constitution. And the other, I suppose, is a response to this time. That and as the argument in the book suggests, there is a progressive nationalization that one sees via what I'm calling the Communal Constitution. And I wanted to think about that, reflect about that, and both of them have come together in the book.
So when you say progressive nationalization, what do you mean?
So that will have to take me to the to the central claim in the book, and the book is trying to respond to the question: who are the people that authorize the Indian Constitution? Right. So, "we the people" is the phrase with which our Constitution starts. The people authorize every major moral political project for the last 200-300 plus years, and our Constitution is no exception. However, following from that, the framing moment that you speak of, try to put together what I think is a liberal secular conception of our Constitution. I think it's the dominant account of Indian Constitution, hegemonic as well. And against that, I'm trying to bring into view or bring for consideration what I'm calling this communal constitution. And when you draw a phrase from you, the communal constitution as I have characterized it, is my idea of what the communal constitution was.
That's right. And I think that when I was reading the book, I felt that this was provided a deep and insightful account as to why the Constitution was colonial. And if I want to come to Matthew's fundamental thesis, it really is that, and as I understood it, so please feel free to correct me if you think of it differently, is that though the Constitution speaks in the name of we, the people, the way it sees the people is not as a coherent whole, but rather through a lens, a communal lens that was used by the British, which is to see the people simply as Hindu and Muslim. Would that be an accurate characterization?
Well, let me, but I think I come at it in a slightly different way, which is to say that the people is an abstraction, right? So we are all part of the Indian people, but the people as there will be the people is an abstraction. Right? So you have to populate that abstraction with some kind of conceptual argument. One conceptual argument is the liberal argument. The liberal argument says the people are a community of citizens. Right? It's our commitment to each other in this abstract commitment to citizenship that pulls us together. Right? The other is, as I'm trying to argue, is this communal idea of who we are as a people. And in the Indian context, it pushes Indian citizens, individual Indians, towards the lack of communal identities. Right? And these communal identities will be Hindu or Muslim or what have you, Sikh, what have you. Right? So that's the claim that I'm making. I'm saying that this has its genesis in the colonial state. Right? And so that's the hypothesis that holds the book together. Right? So I try to trace it at three levels. Right? I say that this is legalized through the conception of toleration. It's socialized through social reform, and it is constitutionalized through representation. Right? So from a period starting roughly the end of the 18th century with the Regulating Act and so on and so forth, pulling all the way into the early 20th century with the various government of India acts, I try to say that there is, insofar as at least religious identities are concerned, an attempt by the colonial state to push people towards these identities.
So the pushback against that would be that while yes, the colonial state does do that, the Constituent Assembly clearly and categorically rejects the clearest basis for that distinction, which is separate electorates for Muslims.
Absolutely. So I was just coming to that. So what I'm trying to say is that there is this colonial conceptualization or colonial characterization of who Indians are as a people. And that characterization was meant to be swept away by this new vision, by this new project, 1950. However, there is a residual carryover of that colonial characterization of who we are as a people. And it's the attempt to put these two visions of who we are that animates the book. And in the process of doing it, I've constantly discovered there's constantly this third form of thinking about the people that pops up at various points. When I'm discussing minority rights, religious freedom, which is the idea of India as a plurality. Right? So neither can capture this social reality of who we are as a people.
We'll come to that in a minute and as to how plurality is different from the liberal secular understanding, and I think there's something to unpack there. But you use the word residual, and that this is a kind of residual understanding of seeing the people as communal. But perhaps it would seem in your argument that it's more than residual. You are ultimately, of course, called your book the Communal Constitution. And if we were to take a practical example, and one of the chapters Mathew talks about, for those who haven't read it, I urge you to pick it up. One of the chapters we talk about personal laws, and this is one of the clearest and sort of more cogent arguments where you say that this idea of personal laws itself, as opposed, of course, a colonial construct where you see the people as Hindu or Muslim, and so you have two consolidated codes of law, Hindu law and Muslim law. And this is something that the Constitution continues, as in by saying through Article 13 that personal laws will whatever, and that personal law will not be tested against the touchstone of the Constitution, and then there's Appa Mali, which kind of sort of cements that. So would it be one accurate to say that it's residual, or do you think it's kind of much more fundamental? And two, in terms of personal law, do you think that that's actually what is going on, that the Constitution still sees the people as Hindu or Muslim, or is there something?
So I suppose I'll hedge it in some way. I mean, I don't have a straight definitive answer to that. So for instance, you shift the terrain to the to the religious freedom chapter. What I'm trying to say there is that it's an extreme case of mobilizing the essential practices test that pushes India towards these nationalized communal identities. Right. So the everyday use case of essential practices does not necessarily lead to these communal identities as I characterized in the book. And so it's not a systematic jump to that. But since you brought up personal law, I think go there. And so it's not an either or. In some cases, these. So I suppose the way to think about it would be to say that the Constitution's design is overwhelmingly different. right? And as you yourself said, several elections, for instance, it characterized the state, but it was not carried over, right? So the important ways the Constitution did manage to push the imprint of that earlier colonial imagination out of this document that we work with today. So to that extent, yes and no would be the way I think about it. Is it residual? Is it not residual? But broadly, one has to the Constitution was authored by a group of people who wanted to put together something like a legal document. Would be my gut reaction to this.
Yeah, but of course, if we look at the fundamental basis for the Constitution, there's a large amount of it derives its conceptual foundations from the Government of India Act. It has this, as I argue in my book, it has this idea of the overarching state that has to be now the guarantor of our liberties. So I see where you're coming from with this argument, but I'd like to take this personal law question a little bit further. And in terms of for those who, particularly those who haven't read the book, could you explain this in a little bit more detail as to why you think that the idea of personal laws is essentially a communal one, especially at a time when we are discussing the UCC, which again seems to be, broadly speaking, I mean, would ordinarily now the way in which this debate has played out will now be seen as communal, but at that time was perhaps seeing the people as citizens and not as Hindus and Muslims.
Right. So again, the argument there is historical and diagnostic, and I'm saying that I'm not sure how many of us have a sense of the historical evolution of personal laws as a legal.
So give it to us in about a couple of minutes.
Right. So in 1770 or thereabouts, the company is possessed of Bengal. They're faced with this challenge of ruling this very diverse society. They, as I argue, are driven by this idea of toleration, and they believe that they must rule their subjects with a tolerant attitude. And in doing so, they commit themselves to tolerating Indians as they see them divided amongst each other. And that division is largely Hindu and Muslim. And in characterizing these two divisions, Hindu and Muslim, they frame the idea of Hindu and Muslims as identities underwritten by doctrinal foundations. Right? Now, my claim, and this is where once again, if I were to pull back to the perhaps a bit of the contemporary movement, these identities, even to this day, cannot be characterized as such. Right? They're not, whatever it is that we call Hindu. Let's just take the example of they're celebrating Ram right now in in ways that people find joyful and at the same time problematic. Right? But Ram is not the icon of one of one exclusive community. Ram is the icon of people going as far as Thailand on the one side, as far as Gordon Southpart on the western side. Right? He is, as Muhammad Iqbal said, he's the Imam-e-Hind. Right? Now that's a sentiment that continues to remain. Right? But that's not how the British saw these identities. They produced a whole body of knowledge that they reframed to say that this is the foundational doctrines of people's understood Hindu and Muslim. Right? And it's driven by toleration. So that's where these identities were legalized. These Indians then assumed these identities and undertook a whole range of social reform projects across the 19th century, producing a degree of self-identification with these identities. So when you look at the entire social reform project in the 19th century, social reform was carried out not as as some kind of universal project. Temple entry was temple entry for Hindus, right? Temple entry was not opening out of religious spaces for for all people. Right? So that's what happens in the social reform period. And then of course, with several electorates, this belief of India divided amongst these identities just gets pulled into the character of the British state. Right? And then there's no going back in a manner of speaking, because you let the genie out of the box, and it's a way of producing ethno-nationalist politics. To me, the finest example of that is Pakistan. India escaped that with our constitution, which is why I like to say that there is something liberal which is valuable and worth protecting in the constitution.
So that's right. So let's then just with a slight digression, let's take this debate on the UCC. Because this could potentially go in two different directions. One is, of course, that, and it depends, of course, in terms of the politics of the moment. One is that it is part of the ethno-nationalist discourse in terms of the fact that you see the UCC in some sense as kind of erasing these distinctions that exist and having this idea of one nation, one code in some sense, and there is some implicit presumption that this code will somewhere reflect or at least not impinge on what is considered to be core Hindu. I mean, I guess that's one side way of looking at it. The other way in which perhaps it was being put forward, though not essential, not entirely elaborated, in the Constituent Assembly by the likes of Vasani and Rajkumari Amrit Kaur, is that this is the idea of moving away from a communal constitution uh, to a framework, and I think again this could go two ways. Sorry, it's going to get a bit complicated. Then this could be kind of a 19th century European idea of a homogeneous nation having only citizens that essentially swear their allegiance to the state and nothing else. So that could be one sense, and that sense, a continuation of a European tradition, or it could be kind of a real empowerment of the citizen himself or herself, and that this is about we the people populated by citizens who are, religionless and nameless and faceless and only identify as Indians. So how do you see this question of the UCC vis-a-vis your idea of the communal cosmos?
So yeah, I mean, easiest answer to this question is that I don't address this question, and this is a this is a techno-legal question that that I don't have. It's a very tangled techno-legal problem, right? And I don't have any real solution to it.
But not solutions, just your thoughts.
My thoughts are that I'm trying to diagnose how we came to this, right? And my thoughts are, however we try to work ourselves out of this moment, we have to do it in a way that is respectful of all of the various parties. Now, given I mean, that's really the only sentiment that I have heard. Right? And so, the groups of people considered Muslim, the groups of people considered Hindu in India, and these are not, self-evident identities as far as I'm concerned. In India today, they are all extremely tangled and complicated identities. They're not self-evident. Yeah. And both these groups have accumulated legal privileges, rights, and so on. And it's going to be a difficult task to untangle them in some new legal frame and system. Right? You've got to work your way towards whatever future it is that you want, slowly through some kind of conversation. I have not embarked on that conversation.
This cricketing terms would be well left. But let me try and pitch another one in that corridor of uncertainty. Because I get asked this question a lot, so this is my chance to reflect this. But a lot of people, when I read this book at this point of time, say that writing a book called The Colonial Constitution at this point of time is essentially inviting a rewriting of the Constitution when the dominant forces are towards creating a constitutional Hindu Rashtra. And one could perhaps have that same view about writing a book calling this constitution, which is hailed as kind of a fount of liberal secular thought, as a communal document, again, opening it up for a certain kind of criticism that doesn't end very well. So how would you respond to this kind of charge?
Well, sorry, there's two things that I was thinking of and one I've forgotten. But the one, I mean, the act of thinking is never, can never ever be too insurrectionary. Right? The act of thinking is always an important part of working towards a better future. And to that extent, communal constitution, colonial constitution, they're all forms of thinking about our togetherness that was more than welcome. There was something else that I wanted to say that slipped my mind right now, but if it comes back, I'll get back to it. No, it's totally super.
Okay, so well left.
But
What? Yeah.
Actually, it's just not. Yeah, sorry.
No, sure, we will come back as we'll have enough more time. Let's go to another point that you make in the book, which is about caste.
Yeah.
And I found that chapter very interesting, and particularly and something that I would like to learn a little bit more on is this idea which you kind of alluded to a little bit, the temple entry is temple entry only for Muslims. So reservation again for Dalits is only for Dalits who have not converted. So it's not, I mean, there's currently a case that's pending in the Supreme Court as to whether the benefits of reservation should go to Dalit Christians. I mean, it's the same argument could be used for Pasmanda Muslims. And so there, as I wanted to ask you that one, what's going on here in terms of the fact that why is it that it's seen in this way? And second, this is this curiosity that I've always felt. I sort of go into it a little bit, but I'd like to hear from you. Is that the definition of Hindu, as Hindu includes Buddhists, Jains, and Sikhs? What's the origin of that, and where does that come?
No, on the second question, where does this origin of Hindus, including certain groups, excluding certain groups, happen here? One could also put in another way of looking at it, like this. Let's take you have one chapter on Gandhi, okay? So now, what is Gandhi's idea of Hinduism? He just says it's a reflection over truth. Right? So any attempt to reflect truthfully about their political traditions in India, he would equate with the term Hindu, right? And and if those people choose to call themselves Muslims, so be it, right? So that's one way to think about this term Hindu. And so, how does one include Buddhists and Jains in this term? I guess it would be that these are as the standard account of it goes, that these are religions of this country. Again, like I think you mentioned that in your chapter on Hinduism, okay? As opposed to so Savarkar's account. These are religions that have come out of India, and Islam and Christianity are something that don't have roots here, right? They face elsewhere in what is their patrimony or whatever, right? So that's one way to look at it. But beyond that, I think the problem of caste to me is, if there is this communal constitution, this is the location where one can see once again the embodiment of this Hindu identity in an extremely important contemporary debate about how we should treat the people who we call untouchable, Dalits, scheduled castes, right? I am trying to argue that it's no accident that Christians and Muslims are left out of the story. There is, something of this communally wrought way of characterizing caste that has found its way into the constitution, which produces this problem. Right? And I try to say that, and as the chapter also demonstrates, there are various ways in which one can think of caste. Right? Caste can be understood, in sociological ways that include Christians and Muslims. Right? So if you read Mark Gallanter's book on competing inequalities, there are cases that he talks about where Christians are excluding Dalit groups from accessing common spaces of worship. And so on and so forth. So caste, and I use Gallanter's work to frame this Hindu conceptualization of caste, so he has this three-pronged conceptual approach into caste, which he draws from the colonial state's response to what caste is in law. Right? So he says there's a varna or sacral account of caste, which I'm arguing is the form that we have adopted in the Constitution. There's equally what I'm calling an associational and sectarian account of caste. In some forms, caste could have religious hues, but effectively, caste is something that you can see everywhere. Muslims could have jamaats, and so on and so forth, or you could just have ordinary groupings, which are purely sectarian. This is groups of people coming together, which you understand to be a Julaha, for instance, in UP, right? Could be Hindu or Muslim. It's caste. So that's how. So all of these have been viable forms of legally responding to caste, but at the constitutional moment we pick one. Right? And perhaps has something to do with this broader communal, overhang, which has influenced the way in which we characterize caste. And it's interesting, I think, that one of the most important ameliorative projects in the independence state has been characterized as a project for one group, excluding others.
Yeah, because obviously in that sense, as it's not something that targets vulnerability alone. But as you said, there is a sacral understanding there. So in that context, again, I mean, these are kind of extensions which are counterintuitive. But the Modi government has announced with the 100 Constitution Amendment that there would be on the basis of economic factors. which is the economically weaker sections, 10% cuts across all religions, actually, which is something that has not been stressed in the public discourse. But that 10% is not just seen, is not just an upper caste quota, which is how it has been seen in the media, but is available to Muslims and Christians as well, who are eligible because of their income criteria. So, how do you see a move like this? Do you see that as desacralizing? It doesn't desacralize caste, but it doesn't look to equalize vulnerabilities and ameliorate them, or do you see this in some other way?
Well, again, very, very complicated story. But if caste is going to be the basis on which an ameliorative uh, program is going to be passion for independent India, then you're assuming that there is this structural social injustice that defines Indian society, which is the problem of caste, which you are trying to ameliorate with these with the entire program, 15, 16, whatever, and an institutional mechanism behind it. Uh, it strikes me that it seems to me that this other quota, this more recent quota, is not a problem of that kind. It's economic equalization. That's right. Which is not really the caste. The caste is, in some senses, like India's founding sin. Right? There's a structural injustice in the character of Indian society. If if you buy the argument.
Yes, and you're saying that it's not mutually exclusive. Yeah, I get that. But in that sense, it is mutually exclusive because it's kind of the same pool of seats that you're talking about. It's a limited pool of seats. So it's about how you're going to cut up.
If you look at it in terms of seats, yes. But if you look at it in terms of what the problem is,
That's right.
it's an entirely different kind of problem.
That's right.
And that problem is constitutional to Indian society, as opposed to an economic, economic distribution problem, which is not so constitutional or fundamental, would be how I would think about the problem.
Fair enough. So last question from me before we open it up. So you mentioned, and sort of there's a hint of that towards the end of your book about the idea of a plurality constitution, which is neither liberal, secular, nor communal, and there were perhaps shades of Gandhi in that. So I'd just like you to elaborate that a little bit because there was only a hint of it towards the end of the book.
Well, there's a hint to it because it's this book, as I see it, is also some kind of ground clearing so that one can think one can think beyond what's worked out here. I do think that the plurality of Indian society, how to consider the plurality of Indian society in a constitutional project is extremely important and very, very difficult task. Now, let's take this example, let's go back to a place where I try to put it on the table, like the minority rights. And there is this identity Hindu, which I there's the Ramakrishna Mission case, which I don't know how many of you are familiar with the Ramakrishna Mission case. So the Ramakrishna Mission, as opposed to as have many other similar groups understood to be part of Hindu society, have argued that they are minorities. Okay? And in trying to respond to this case, the court is pushing the groups like the Ramakrishnas towards something of what I'm calling a communal, towards a communal understanding of what the Hindu is. So it's an ethno-nationalist understanding of what the Hindu is, right? And in the process, losing out on that plurality that exists in Indian society. Right? So what I'm trying to say is that this identity Hindu or this identity Muslim is not self-evident. Right? If constitutional practices could work towards some kind of pluralization, I'm not sure where we could end up at. Yeah. That's the only hint that that I can put on the table. Beyond that, it's not fleshed out as far as I'm concerned as well. Right? But I do think that this plurality defines us, in fundamentally important ways, right? And it continues to be with us.
Do you say that plurality in religious terms, or do you have any other kinds of plurality in mind?
Well, the book primarily looks at the case of religion, and so I'm examining it in religious terms, and perhaps its plurality of all kinds defines India, and these pluralities escape forms of constitutionalization that that we see that I try to etch out in this book, and how to respond to them, think about them. That's the task ahead.
Yeah, and ultimately, I guess it would come down to the question of actually what makes a nation, because in somewhere we are in this construct of a nation as this homogeneous entity, and we're trying to push towards that, which itself is a construct that perhaps has never worked in India historically, of having this kind of overarching identities or kind of consolidated wholes as being the fundamental basis for the nation. I think plurality somewhere has been kind of the cornerstone, but maybe not a nation as we see it in these kind of geographically bounded terms that we see today.
That's actually throw the question back to you. You have a whole chapter on Gandhi, which in your book, which also tries to in some ways grapple with this problem. Right? There is Gandhi trying to think about the nature of Swaraj, right? And the nature of Swaraj, if you look at Hind Swaraj, for instance, is something that each person works out for himself, as he says. Right? And then you have to have the context within Swaraj can be actualized. And plurality perhaps is one such context.
Yeah, and I would say that, like you, as this is not very well fleshed out in the book, because I think that there is a long distance to travel between ideas of plurality, which is where, which is sort of in the realm of concept, and where we are in terms of the constitution. I think there are many steps that are there with I mean, if you were to take the constitution at this level, I think then over and above that, there is our political system. I think over and above that, there is the way in which we think of law, and over and above that is the way in which we think of the nation state. I think these are all these leaps that you have to go before you get to this kind of Gandhian understanding of what's happening with plurality. So it's very hard to translate that quickly into a constitution, because then you get answers that are unsatisfactory. This is what was happening, and so and I think this is what happened a little bit with Shriman Narayan Agarwal, who does this document called the Gandhian Constitution. Is that when you're trying to translate that into legal text, it kind of becomes quite administratively nightmarish, because then it becomes okay, every village will have its own panchayat. So does it mean that there could be different ages of marriage in village X and from village Y? Okay, how will trade happen? So when you think about these kind of conceptual questions in a very fleshed out practical way, it becomes very difficult. So I also don't have an answer. This is my turn to let the ball go to the wicket keeper.
So I suppose methodologically, I have in the book, I've done what you're calling let the ball go, artfully or not. I don't know. I leave it to you to decide. But these are not problems that one can resolve institutionally or constitutionally or legally easily. But you can use law as a site through which you can explore some of these fundamental issues, and I think that's what I try to do in the book.
Well, that's right. And I think that's why the book is a really useful contribution. And I think that's a good note on which to open it up. I do have a few more things to ask, but I'll open it up. Aditya.
Good evening, sir. So I'm Aditya. Implicit in what you, so I haven't read the book, but implicit in what you said today is this sort of a grid between liberalism, citizen, individual level, and what you say, ethno-nationalism to the community. And this is, of course, definitionally, this is how it is, because we associate liberalism with freedom and conservatism with another strand of here. But does it necessarily have to be this way? Like, as in, are we condemned to this grid? And in a way, this is the debate between Gandhi and Ambedkar. But also we see, because if you look at liberalism, that basically means that there is an isolated individual and now there is a state. And the individual is supposed to negotiate with the state about rights, privileges, claims, etc. Except it doesn't, I guess, never happens that way. So is this grid all there is to it, or conceptually can we move beyond it and see the community as a source of freedom, the community as a source of rights?
Yeah. So the question, so let's start from the other side, which is, like in the way you characterize it, there was community and what is the other one that you used? Yeah. So the problem with ethno-nationalist characterization of the community is that it is a particular form in which community is characterized. Right? So you are trying to put together ethnic and geography. Right? Now, the problem with that is, as far as I'm concerned, is that you are immediately condemned to friend enemy, inside, outside, us and them. Right? Now, that form of community is purely is going to very quickly lead you to trouble spots. Right? So it's against this conceptualization of political community that liberalism comes in. Right? But it faces the problem that you are putting on the table for us to consider. Right? Now, that's in the Indian context, that's where perhaps there's something about pluralism. I don't know, how one brings it to bear because I've not done that work. But if you look at Western societies, right, this move towards liberalism is a move that comes out of Christian society in debate with itself. Right. So there's Catholic society that imagined itself in a particular way as one community under God, and then Catholic society reformulates as one conscience under God. Right. So Catholic society needs the mediator of the church. Protestant society no longer needs it because you have now become the priest. You don't need the priest. Right. But it is a community over time that has its own solidarities. Right. So it's not that Protestant society, when Martin Luther for the first time comes up with this new idea, suddenly loses solidarity. It's a society that is, that has its solidarities. Right. Now, in a society like India, what are those solidarities that we can mobilize, generate, and and produce these, the gaps that liberalism leaves out is the task. I don't know, I don't have an answer to that, but that's how I would think about it.
May I just ask a
Yeah, sure.
follow-up question? So you said ethno-nationalism leads to trouble spots, like you said, but any attempt to exclusively define a community will have an inclusion and will have an exclusion. So insofar as that is the case, it will lead to trouble spots even if it's not ethno-nationalist or even if it's not ethno-religious. Any community, however so defined, if it is to be discrete, will have an exclusion. And as long as it has an exclusion, like you said, there will be trouble spots. So that problem also exists, right?
So there are scholars. Yeah, go ahead.
Sorry, very sorry. And it will be so, especially now, because, like you said, in the 18th, 19th centuries, we underwent a process of self-identification. And that's when we began to think of ourselves as Hindus and Muslims and these discrete categories. So once you have these discrete categories, then to me, at least, that problem seems inescapable of having solidarities without having boundaries, in a sense, if that makes sense.
I didn't quite catch the last point, but on the problem of the inescapability of these identities, I mean, there's a scholar called Claude Lefort who talks about the empty space of power. So that's the characteristic form which modern societies define political power. Right? That space of power is left empty. Anyone can make a bid for it. Right? So there is identity, but that identity is a fluid space. Right? So there will be provisional insides and outsides, but it's not cast in stone. That's the problem with internationalism. So which is where the problem comes.
And I think there could be solidarities that cut across communities, no matter how you define those communities. I think in a different world, as a Ram can still be an Imam, right? I mean, I guess that's a solidarity that cuts across communities and did cut across communities at some point of time, but perhaps is not doing so now. And I think that's
Obviously, yes.
maybe it is, but
We're not looking hard enough to see it.
maybe that's also the case. But yeah, I think there's a lot of food for thought there.
Yash. I think I have a couple of questions, and well done with the name, because as soon as I saw it on Twitter, I'm like, this is another one they've got to justify their communal projects in English. But I read a few reviews, and that's what kind of went beyond the. But it definitely piqued my interest to try and but I guess a couple of questions that I had were. Number one is you spoke about the people as an abstract and how the framers kind of, and I haven't read the book, I haven't had the benefit of reading the book, but just by the opening statement was how the framers sort of saw the people as distinct communities. But have you dealt in the book with particular cases, which have, such as the first one that came to my mind was Beecher and Manuel, which essentially has used the very constitution and the case law that it's been built on to treat a very minute sect of people, and they relied on those cases from America, to justify that everybody has to be treated in the same way. So they kind of used the constitution to not segregate, and put the smallest of the small on an equal footing. That's number one. And number two, I guess in today's day and age, the subaltern vogue phrase is fraternity, which is a much more important phrase in our book. And like we spoke, I think we can conflate plurality, what we were speaking about right now. But I mean, have you sort of dealt with that? Because a lot of, a lot of cases have dealt with that. So I guess how have you dealt with in this book? How you dealt with case law, particularly instances?
Yeah, thanks for that. Yes, yeah. I have dealt with essential practices, primarily in understanding religious freedom. And Vidhi Emmanuel actually, is a case that that cuts against the grain, on this story, right? So it's not a case that I have looked at. Right? So I have looked at the imprint actually of the Gajendra Gadkar High Court, and Supreme Court on subsequent cases. And this is one case that stands out, and it stands out in being precisely the kind of case that you have just outlined for us. So I've not looked at it because I'm interested in something else in these lines of cases, trying to elaborate what is essential practice. So, I started question roadmap like what people do, and and said that there's something interesting that takes place in the Gajendra Gadkar Supreme Court. His modernist vision transformed the idea of essential practices. And I tried to ask the question, where does that come from? And I trace it back to the story that I've just outlined very before. So on that question, no, I'm not left with visual with in the form that you're asking me. As far as fraternity is concerned, I'm no, I'm not there with fraternity as a problem. But I am, at some level, I'm not unmindful of the liberal fraternal project that the Constitution wanted to bring into effect. Right? And I think that there's something to it. How we get there is a question. But that again, it's not something I've worked out in this book. This book is a very narrow book, trying to pull out one problem, and I've done it in the form that I have characterized for you. Right? But yeah, I'm sympathetic to the need for some kind of fraternity that pulls us together. That ties up to Vidhi's question as well. You do need some kind of solidarity, right, in a political project. How do you pull that together?
It's the core of the first.
Yeah, absolutely. But that's the challenge. But these are higher order sort of problems which I have not unpacked in this book. Yeah.
Hi, I'm Lalit. Thank you so much for this talk. I just wanted to ask you in the context of your choice to question this particular paradigm of a liberal constitution. I just wanted to compare what you're suggesting with some literature which is existing, which would still suggest the constitution is liberal, which is in the context of secularism and let's say even personal laws. There are a number of scholars who try and characterize the way in which Indian governance works on these questions as still being liberal and even more liberal than Western jurisdictions. So, for example, when Rajiv Bhargav talks about what secularism is like in India, he's suggesting that this is how other countries should also be considering maybe their own legal systems. When scholars talk about harmonizing personal laws, and they're talking about gradually harmonizing it. They're talking about a way of dealing with these questions which is more sensitive than maybe what is happening in other countries. And this brings to mind, to me at least, the manner in which, the way in which Western law has looked at such questions, that manner has shifted over time, perhaps in a way that has moved in the Indian direction. It used to be more formally equal, but they have become more willing to accommodate with time. The idea of affirmative action at the time of 1950 was not very popular across the world. In a sense, in this context, we have been proved right to some extent that affirmative action is a good thing and it needs to be considered in its own life. Would you say in this context that this is a problem with considering the constitution communal? That in fact it might be more liberal than we have the imagination currently to imagine it to be?
Yeah, thanks, Anand. Once again, as I was trying to say to Orgo right at the beginning, I'm not saying that the constitution is like overwhelmingly communal, right? I'm saying that there is communal conception of the people that has seeped into the constitution. The effort in the constitution was to bring into being and to institutionalize and constitutionalize precisely what you had just spoken about, right? Alongside that, there is this other way of thinking about who we are as a people. And in modern times, we cannot escape the project of organizing ourselves as a people in some form or the other. Right? And an extremely influential project of thinking about who we are as a people is this communal form of thinking about India as a people. Right? It stands juxtaposed to the liberal project that you have just outlined. Right? My efforts was to put on paper, was to effect this juxtaposition through the book, right? And without taking away what, without, so now the question is, what does this mean for the liberal project? Now, I try to suggest that, like in the chapter that addresses the question on religious freedom. And I suppose one way to think about it would be the Sabrimala case, right? The majority talks about essential religious practices in this broadly sort of essentialized communal form that I am, that I'm trying to put on the table. But trying to move away from that position are the two minority positions of Chandrachud on the one hand and Indu Malhotra on the other. Right? Both of them, one takes some kind of position, or it takes Indu Malhotra, I think, is arguing for some kind of community driven autonomy as a way to think about what is the freedom that one must accord to groups in relation to their freedoms in 26B, right? And Chandrachud says we need to move well past this essential religious practices test. So so there you have it. In some senses, you have various forms of various ways in which one can think about how to think about various ways in which this the idea of the people is constitutionalized in one doctrine. Right? And that's one way to think through what you're trying to do. What I think you're trying to put on the table, right? And my response would be to say that this is the juxtaposition. Right? I don't know if I've done a particularly great job of responding to, but this is my.
Just a very quick follow-up. How far do you think we need to shift the focus of discussion on communities in India away from, in law at least, away from the essential religious practice doctrine towards something more about the right against religious discrimination? Is this something that
Perhaps we do, perhaps we don't. I don't address that problem, so I'm going to again. But I was just trying to talk about the juxtaposition, different ways of thinking about how to define the scope of religious freedom. And I was trying to, you spoke about the fact that they have a particular kind of secular vision. And I'm trying to say that, many of those many dimensions of that secular vision continue to be with us in the Constitution. And this communal, the disposition or tendency to communalize is one such.
So, follow up to that, how would you characterize the plural vision of the Constitution as different from a secular vision?
The plural vision is large in the book, and in the manner in which I characterize it in the book. It's not a constitutional vision. It's sociology pushing against the design and practice of the Constitution. So so to the extent that Indian society and Indian social practice exceeds the attempt to constitutionalize, you have this plural problem that I don't think we made enough of an effort to grapple with and understand. Yeah. Okay.
Yes. Yeah. So hi, I am Mohammed Jameel Reza. What he said, and I'm continuing Lalit's question. So in 2022, I designed a research study which said that whether the secularism in Indian constitution is an adjective or it is already there, and the addition which was done in the preamble was a necessity. So for that study, we talked to one of your colleagues, Professor Mohsin Raza Khan, and he said that the addition in the preamble was an adjective, but secularism has been in the constitution in bits and pieces, and we can find the traces there. And the argument which you are making that the constitution is communal, he said that the the discrimination or things which are there, it is not part of the constitution. It exists within the communities which the constitution fails to address. Like you said about entry into the shrines or temples and things like that. So whether you believe that, like I'm asking the same question, whether the secularism in the Indian constitution is an adjective, or you believe that the communalism which is there, it's only within the communities and not across the community.
I'm not sure I've got the question of secularism being an adjective.
Yeah.
Could you?
So I'm asking that whether the secularism which is there in the Indian constitution, it has been there, and the communalism or the discrimination which you're talking about, it has been inside the communities, like whether it's the entry in the temple or a shrine, or essentially other essential religious practices, or it is cross-cutting across communities, and the secularism is actually adjective in the constitution.
No, I mean, I think secularism is deeply part of the Constitution, with or without that word. Right? So the Constitution does provide for the right to religious freedom, the right to equality, and all of that is an integral part of the Constitution. What I'm trying to put on the table is, in addition to that, there are ways of understanding this Constitution project, where when a different form of thinking about who Indians are as a people trickles into the Constitution as well, right? And that is in addition to the fact that India has tried to put in place a liberal secular constitution.
So it seeped into the making process. So the constitution, you believe that, like this is the question, that do you believe that the constitution has failed to address this within the communities or the cross-cutting of the communities? Because most of the essential religious cases, if we'll see, it is within the community. They are fighting in the community that, okay, I won't let you enter the shrine, I won't let you enter the temple. This is not a essential religious test.
Right. So maybe it makes sense to pick up one of these cases, right? Think about it. Like let's I mean, it's not an either or, right? The cases that the court deals with do deal, for instance, let's take these temple entry problems, right? Which and like you can take.
There's a temple entry case, there's a shrine entry case, then there's a Jammu Kashmir High Court case where an argument was that X community could not be the priest in our temple, and a person was made priest. So if we leave Farsi versus Union of India and such cases behind, mostly it is the essential religious cases have been within the community. There are a series of judgments.
Sorry, I'm not quite catching. When you say essential religious practices stays up within the community, what follows there?
Yes.
What is it that follows from that assertion?
So, most of the cases of essential religious test, if we'll see, the community is fighting in itself rather than fighting from another community or from the state.
Okay. Yes. Yeah. Sure.
So, now when you're saying the constitution is communal, it is whether the communalism or the discrimination is within the communities or it is at the cross-cutting of the communities.
Right. Okay. So, see, what I'm trying to say is that essential religious practices is a doctrine. Right? Now, I'm not saying that every application of this doctrine is inherently communal or not, or not communal. It has a tendency to communalize. Right? And it communalizes in certain extreme case scenarios is the claim that I made in that chapter. Right? And I'm trying to say that it has a certain history. Right? The history is one that tries to identify communities with foundational doctrines. Right? And Indians have bought into that history, which then becomes a tool of constitutional interpretation, which I then illustrate in in the independence period through the Ayodhya decision, right? Where so it's not to say that every one of these cases is is an illustration of the communal character of essential religious practices. No, that's not the claim. Right? I'm saying that it has the potential to produce community in an ethno-nationalist form. Right? And it has a prehistory that disposes it in that direction. Right? And the Ayodhya decision to me is a decision where where you say that Ram is essential to an excluding community. That's where you see essential religious practices producing an ethno-nationalist conception of who we are as a people. Right? Even though I don't think Ram is anything like that in Indian society.
Thank you so much, sir. I wanted to ask, to what extent do you think the way in which the Indian Constitution approaches religion is just one facet of the reluctance of the framers or the Indian state in general to allow society to evolve in unplanned ways? I mean, for example, what Olivia was talking about panchayats and the very difficult thing to write a law about. I mean, the sort of quasi-libertarian answer to that would be that you can have order without law. You can allow people to develop their own solutions, which coalesces into a coherent body of law over time. So, what would you say about that?
Perhaps an element of proof to that. So essentially, essential religious practices test, forces courts to discover what is essential and foundational, and is less open to allowing communities to, to determine what is it that. So for instance, like take this a case like the Anand markets. Okay? The court forces these communities to produce a book. Okay? But perhaps this is a community that that does not really care for them.
Right.
But the court forced the community to produce a book, and they then they went back and produced the book, and then the court is not sure what to do with this book. Okay. So perhaps an element of truth to what you're saying.
But that's the upshot of summary one as well, in some sense, that you're creating some clear conditions of how you can be seen as a particularly discrete community. So it kind of forces sects to define themselves more clearly vis-a-vis the outsider, and have books and have particular practices so that they can be defined as a community in a certain way, so that they also get entitled to those 26 benefits. And I think the one thing though we should recognize is that essential religious practices is a doctrine. It's not something that's in the constitution. And it is a doctrine that by definition, as it has, is as you were saying, is internal to a community. Because it is by definition that. So any use of that doctrine will, in that sense, necessarily communalized. This is how I saw that. And so any application of that doctrine, even if it is in a kind of fairly non-controversial case where you see something which is perhaps clearly an essential religious practice that someone doesn't need to get into, I would say that even there would be a kind of de facto communal conceptualization that comes in. Any final thoughts? We had a good discussion. We are exactly at an hour where we want to be. You have one final.
Yeah, this is actually a question that colleague of mine was wanting to ask and struck me as well. I think what she wanted to ask was, why would you have chosen the word communal and not communitarian? Is that something that strikes you as
That's a condition.
No, no. I mean, the communal word draws from from the colonial constitution, right? So in the colonial constitution, this was the way in which they understood the character of Indian society, right? And communitarian has a very different, it's understood very differently in political theory, right? So it means something entirely different. Communitarians are basically liberals who try to bring into liberalism something of the power of community, right? So that's not what I was trying to say. So communitarian was clearly not an option. And the colonial state did talk of India as a collection of communities, right? And therefore they understood the problem of governing India as essentially the communal. Right? That India is a collection of communities, each at each other's throat, each at the other's throat. Right? And for them, there was no possibility of a people. Right? And and they saw themselves as being pedagogues, people who would tutor India towards becoming people in the future. And so it's in that sort of milieu that the word communal, comes into the
Last one. So, sorry, pardon my ignorance. I have not read the case which you mentioned here, where you said that the court forced. So, what do you meant by court forced to produce a book?
Yeah. Oh, the Anand Marquis. It's not that the court forced. They asked. The Anand Marquis were a community that there are certain rituals that they performed with skulls and tridents in public, right? And this was subject to restraint. And they argued that it's part of their as part of their affairs. It is a matter of religion to their denomination. At which point the court asked them, show us evidence, show us a text. Right? And to that question, they came back with a text.
So this is now this says that it's completely court's discretion when they want and when they don't want. Because if we will see the Karnataka High Court hijab judgment, they produced their judgment on the basis of Surah Al-Nur and they didn't look at the Surah Al-Hijab, which makes it the essential religious test, like essential religious practice. And when it came into the Supreme Court, so now the force, but it depends on the court when they force and when they do not force.
Right. So courts are discretionary actors, right? And what I'm trying to do is that I'm trying to tell you that this particular move, a doctrinal move, Otto saying, doctrinal move is outside of the constitution. It has been brought into the constitution to understand the content of articles. And in interpreting that, courts are discretionary actors, of course. But in being discretionary actors, they choose certain doctrines. And I'm trying to say that this doctrine has, I'm trying to locate it historically. Now, you may say that my historical sort of story about essential religious practices is incorrect, which is fine. That's an argument that we can have. But essential religious practices is a doctrine which has a certain form in which it manifests in its operationalization, and it produces, at least in a case like the Ayodhya decision, a tendency to ethno-nationalism is my clear.
For all of us who deal with the law on an everyday basis, I think this book is a welcome reminder that there is a history to every legal provision, there is a history to every legal doctrine, and there is certainly a history to the Constitution itself that goes well beyond the Constituent Assembly and into the deeper recesses of our mind, whether shaped by colonial forces or even forces perhaps before that. So thank you, Mathew, for taking that arc back from 1950, not just to 1946 or 1935, where many of us go to, but right back to 1778 or whatever that, and when the company comes in 1757. So thank you very much for writing this wonderful book. It is certainly going to provoke a lot of disagreement, but if you can provoke people into disagreement, then you can certainly provoke people into thinking for themselves, and I think that would be great service at a time when we perhaps are not thinking enough for ourselves. So thank you very much for writing the book and for this book Adda today. It's been a real pleasure having you, and thank you very much for everyone who's joined here today and the folks who joined online. It's been great, and wish everyone a very happy weekend.
Yeah, thank you, and thank you for sharing some part of your Friday evening with the book and with us. Thanks very much. Thank you. Good night.